Holmes, you may proceed.
Thank you, Your Honor. As the court can see, Mr. De La Rosa is an amputee, in which he suffered from injury a few years ago. Your Honor, we're requesting if the court would consider probation. I believe that Mr. De La Rosa would benefit from being on a mental health caseload as well. He does suffer from some mental issues that I feel that would be beneficial if he could receive care through either MHMR or Spindletop. He understands that he does have prior convictions, so as a convicted felon, he cannot possess a firearm. And he understands that moving forward, no matter what situation he's in, he cannot have a firearm. Your Honor, he does have 2 children that he would like to be better involved in their lives. One of the main issues that I see in the PSI is education. He has a 6th grade education. I think it would also benefit if he would be allowed and participate in the GED program through the probation department as well, to help him to develop some skills so that he can make better decisions and get his high school, at least minimum high school equivalency. There isn't much history in regards to substance. With regards to substance abuse, looks like maybe alcohol that he drinks on occasion. And he has no problem, it says, in his recommendations to avoid any association with the co-defendant, Ashley Faye. And as I stated, Your Honor, he would be willing to adhere to any referrals or treatment plans or directives that probation may recommend. And so we are requesting probation.
Thank you, ma'am. Mr. Nichols?
Your Honor, he has 3 prior felony convictions, 1 for being a felon in possession of a firearm, 1 for aggravated assault with deadly weapon. He should have been habitual. I took into consideration his health issues when I made the offer of an 8-year cap. I don't know that he deserves any more consideration for what has happened to him. You see his gang history, his criminal history. I think 8 years is appropriate in this case.
And I'm sorry,
Mr. De La Rosa, you wanted to say something?
I do got priors now, but I don't know like juvenile stuff like that.
So in 2015, you were not a juvenile.
2015 was that when that conviction was like I think 7 years.
That was your conviction for unlawful possession of a firearm by a felon. And you got a 2-year sentence.
Yeah, no, but I did my time and I did parole. I did good behavior.
Right. So you should have learned. Not that you can't possess a firearm. I mean, and Ms. Holmes is doing the best she can, saying that, you know, you understand and that you can't possess a firearm, but you've already gone to prison for that. So
I was at the wrong place, wrong time. Now, I mean, it wasn't my position due to the fact that I am a felon. I'm not denying it, but you know, I would deserve I feel like a second chance or something.
well,
I always keep like I want to get thrown in prison, come out when I'm 38, something like that.
well, and I understand. Well, and here's the thing, Mr. De La Rosa, nobody wants to get thrown in prison. And what I do today isn't anything that I'm doing. It's where you've gotten yourself with your history since you've been a juvenile into being an adult, knowing that you cannot possess a firearm. You've got 3 prior felony offenses. 1 was when you were certified as a juvenile, that first one. And then if you didn't understand the law about deadly weapons, you should have, or carrying a firearm, you should have back in 2015. I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty of unlawful possession of a firearm by a felon. I'm going to sentence you to a term of 6 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement I followed, so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Obviously, we know this now. I'm required by law to read this to you. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Ms. Holmes. right, good luck to you, sir. You can go back with the bailiff.